Any mention?
Please, Your Lordship. Your Lordship, I beg to mention item number 4. Item number 4, Your Lordship.
No, 4. Yes.
Your Lordship. Mr. Piobin is on leave, Your Lordship.
Who is appearing for the petitioner?
I'll inform the other side, Your Lordship. After vacation, Your Lordship.
Yes, requested by
Duly
the Land
obliged.
Council for the petitioner. Land Council for the respond number. State is not a party here.
I apologize, my lord.
How many respondents are there?
Only one, Your Lordship.
At the request made on behalf of the respondent. This is matter of course.
Duly obliged, Your Lordship.
Supplementary causes. Item number 1.
Wait, please, Lordship.
Yes.
Lordship, we are aggrieved by the order passed by the
This is a revision, civil revision.
Yes, my lord.
Why before this court?
Because Justice Dingdo is not available, and Justice Thank You has recused.
Oh, Justice Thank You has recused.
Yes, yes.
This is the matter you mentioned yesterday.
Yes, yes.
Yes.
So, my lord, we are aggrieved by the order dated 14/11/2024, passed by the presiding officer of the Court of District Council in Makurwat, my lord. In that order, my lord, we have filed an application under Section 94, read with 151 CPC, in which we have
Supplemental proceeding.
Yes, my lord. Because what has happened during the pendency of a suit, we have filed a suit, my lord. So during the pendency of the suit, the workers of the petitioner herein, they went to the suit land and they found out that there are some people who are carrying out construction in the land. So when they asked them who are giving you permission, they said that we are carrying out construction under the instruction of the respondent. The respondent is the defendant in the title suit. So what we have done, my lord, we have filed for supplemental proceedings under Section 94, read with Section 151.
There was no application under Order 13/1 and 2.
Initially, my lord, during the motion of the suit, when we filed the suit, my lord, we were aggrieved by the fact that this is a joint property. This is a joint property, my lord,
property
of the petitioners and the respondent. Because what has happened, my lord, there is a history wherein in the year 1990, a suit was filed between the petitioners, predecessor of the petitioners, and the Dorbar, who is the respondent, my lord. So after 21 long...
Dorbar is the respondent here.
Yes, yes, my lord. He's the acting CM representing the Dorbar. So what has happened, my lord, after 21 long years, finally a deed of compromise was executed, and after that a decree and judgment decree was passed wherein it was agreed that the suit land will be a joint property of both the petitioners as well as the Dorbar.
Land is situated where?
There in the southwest.
This is a rekinty land or reride?
My lord, through this judgment compromise, it was agreed that this will be a joint property.
No, just a minute. We have a difficulty in understanding.
Yes, my lord.
How do you own a joint property with Darbar or the CM?
Yes, my lord. My lord.
See, as per the land system prevailing the Khasi, there is either rekinty or reride.
Yes, my lord. Yes.
Now, reride is basically controlled and administered by the Siddhar Sip.
Yes,
or
my lord.
CMC.
Yes, my lord.
Now, can you own a property jointly with the authority concerned?
Yes, my lord. If by consent, my lord, because here.
When by consent, how you will own it?
Because what has happened.
You do not understand difficult proposition. Then it becomes, when you own it jointly, what is the status of the land then? It is a reride or rekinty land?
This is a hybrid of both rekinty and reride.
How can it be? You see, there has to be recognition in law. The question comes today, say supposing here the government land, DC revenue is the authority.
Yes, my lord.
Can I jointly hold a land with DC revenue?
No, my lord, because what has happened.
Jointly hold.
Because what has happened, my lord, originally in 1990, the contention was the Darbar was claiming that this is the land of the community land. We are saying that no, this is a private land. So after that, my lord, after 21 long years, both sides have taken a middle path, said, okay, we'll jointly own the land. So after that, rightly or wrongly, my lord, I understand the.
See, then it will become difficult to determine who owns the land, because even that compromise also, how this compromise will be operative in law then?
No, because this compromise, my lord, what has happened, in this compromise, we have agreed that this will be a joint property of both the petitioners as well as the respondent.
Very difficult proposition. How it could be? How it can be?
Because there are situations, my lord, with all,
Then if a question comes
Mhm.
of dividing or partitioning a property, how it will be done?
with the consent of both parties, my lord.
And then without consent, nobody can claim partition.
No, no, my
How
lord.
can it be? If you are joint owner of a land, you say that one party will be barred from claiming partition. Claiming partition when it comes, when there is a difference,
Mhm.
then the question of partition comes.
Partition, if it's
So
with the
you want to say the Darbar or yourself, you will not have the right to claim partition until and unless the other side consents.
yes, my lord,
Cannot be a law like this. How can it be?
because that is what is.
See, there has to be a legal. See, we do not know that is how it is possible at all. Then now this present case is also between the same parties.
Yes, my lord. Because
Then
what
what
has
happens to earlier settlement? Then why a fresh
no,
case?
no, no, that's what, my lord, I'm coming to that, my lord. Rightly or wrongly, this judgment was passed wherein it was agreed that this is a joint property of both the parties, and that whatever decision should that is to be taken in the suit land will be with the consent of both parties. So now, my lord, what has happened on the on February of this year, this aim, because what has happened, my lord, the original aim was removed, and then acting aim comes into the picture. So once this new acting aim comes, my lord, he unilaterally issues a kind of a notice, my lord, in which he have called for tender of of calling people to collect revenue from the suit land. So because of this, my lord, we have filed a suit, and during the
Revenue
motion,
from the suit land.
yes, my lord.
Revenue from the suit land.
Yes,
Revenue
my
on account of
my lord, because there are some people who are there, my lord. We have rented the land. Then and there are also people who are carrying out some limestone and all, my lord, and those things. So that's why, my lord, on that basis, this particular land, my lord, because it's a huge tract of land. So whatever income that arose from that, this CM has issued a notice in which you have called for some people to collect those revenues, my lord. So we are aggrieved by that, and then we have filed a suit. And during the motion of the suit, my lord, we have filed for initial stage, we have filed for injunction under Order 39 Rule 1 and 2, in which we have said to put a stay to this particular notice, my lord. So accordingly, the same entered appearance, and after that, by the intervention of the court, because it was very apparent, the same also does not dispute the fact that this is a joint property, and he said that okay, let receiver be appointed by the court, two from our side, two from their side, so that they'll collect the revenue. So accordingly, Order 39 Rule 1 and 2 was disposed on that line, my lord, in which it was agreed that
so it was also compromise.
it's sort of, my lord. Yes. Yes,
Settlement.
yes,
Maybe
yes,
temporary in nature,
yes,
but then
yes,
it's a settlement.
settlement, my lord,
And the receiver is
appointed.
then purpose of section 94 is served. Then
No, because what has happened, my lord, now what has happened after that, my lord, the suit is still pending, and then these people, what has happened on the 4th of November, my lord, we went to the suit land, and we found that someone is carrying out construction, and we asked these workers, why are you carrying construction here? They're saying that we are carrying construction on the basis of the instruction of the CM. So accordingly, we filed this 94, section 94, to stop the construction, because they are using machines also.
once there is a receiver appointed,
Mhm.
what is the report of the receiver then?
My lord, receiver is only to the extent of collection of revenue, because our injunction at that point of time was with regard to the notice, and notice talks about collection of revenue. Regarding the construction, regarding the usage of land, there was no application.
Where is your application under Order 39 Rule 1 and 2?
Yes, my lord.
Let us see what prayer you have made there. See, things have become very complicated. We do not understand. See, like we have not understood how to determine right of individual in a joint property where Darbar is a co-owner.
Yes, my lord.
We have Darbar or the Siddharship is co-owner.
My lord,
We do not know. We do not know because the title of the land. If see, like there will be huge difference if it is a rewrite and recantee. Determination of ownership. You see, the basis for determination will be totally different.
my lord, so far as that issue is concerned, that suit which was looking after was already
You see,
disposed of, my lord.
your very claim of ownership is on the basis of that only.
Yes, my lord.
There is a compromise decree.
Yes, my lord. And it's not disputed by the other side also, my lord. Other side is also not disputing this fact. My lord, so far as the Miss case is concerned, my lord, it's at page 242, my lord.
That is your application under order 39 rule 1 and 2.
Yes, during the motion stage, my lord.
Proceeding is before district council court.
Yes, my lord.
Why you have come to High Court?
Yes, because, my lord, what has happened, my lord, when the original suit was disposed of, TS number, that TS of 1990, then after that, my lord, subsequently there were some parties who are claiming themselves to be the members of that particular steamship. So they have filed some application before the trial court to revoke that judgment and order. So that was rejected. They filed an appeal before the judge of district council court, and the judge district council court as well as the additional judge, what they have done, my lord, they have referred the matter to the High Court because none of them can take up the matter. Because at some point of time when they were the presiding officers, they had a hand in the matter. So after that, this honorable court, my lord, will see I've annexed the order in page.
Just tell us. You do not
yes.
have to refer. Just tell us.
Yes. Then after that, my lord, this honorable court has transferred this their appeal, my lord, that was pending in the judge district council to the judge Joy, district council court Joy.
This should have been the same thing. Once there is an appeal maintainable,
Yes.
how come a revision be entertained? Rule 6 has to be strictly in accordance with section 115.
My lord, then if my lord gives me the liberty and I can directly approach the district council Joy, then
It cannot be. You file your appeal there. Let another order be passed by the authority therein. Then only you can come for transfer. You cannot take shortcut.
my lord, because this revision also, my lord, 227, this application is also under 227, my lord.
227 comes
Because
in
there's no
extraordinary
bar
situation. Now, see, you have made it very complicated. I do not know. You see, like, at least for this court,
Yes,
this
my
court
lord.
you have to go into.
I understand, my lord.
that.
I apologize.
First of
Perhaps
all,
I'm not really in a position to really.
See, 94 will not be appealable under 104
Yes, my lord.
CPC, isn't it?
Yes, my lord.
Am I correct?
Yes, my lord. But because of the
This court
judgment.
is out of civil thing for quite some time.
Yes.
See, anyway, this is not appealable. You can understand that. But then under the rules, it is appealable.
Yes, my lord. Actually, there's the judgment of Westerly Dakar also. It says that any of the Supreme Court, which says any order of the subordinate court can be appealed to the district council court. Because
Even in spite of that, also, I think Rule 28, maybe the 1953 rules. Just see,
yes, my lord.
order passed is available. Okay,
Yes, my
and if you see, that is what, because the district council proceeding spirit of CPC will apply. So the rules will have the primacy, even in spite of the fact that CPC has been made applicable throughout the state.
But
Proceeding before district council remains intact.
my lord, my limited.
No, but then in such a case, you should have filed an appeal and should have allowed some order to be passed by the authorities therein. Then you approach for district transfer of this.
Because what's happening, my lord.
See, this result in, you see, like maybe all right for you. For the other side, they will be losing on forum.
Not because what has happened, my lord. Now there's some urgency because construction is being going on.
You can understand urgency is there, but then you cannot bypass law.
Lord, if some
115, you will have very limited this thing. You have to only argue on jurisdictional aspects.
yes, my lord, and we have come under that Rule 6 of the Meghalaya rules, my lord.
The decision of our High Court, rule see, has to be strictly in terms of section 115. The scope is same. That is
But
what
we have also come under Article 227, my lord, because Article 227.
What for? Why?
My lord, Article 227.
No, Article 227 at in what situation we can interfere under?
My lord, there's one judgment of the Honorable Supreme Court.
What does it say? Just say. Just you should
ju-
tell us. We are
if-
interjecting.
yes,
First, you will
yes,
come to papers and all. Just say what
Yes.
does it say?
It says, my lord, that if the Honorable Court has power but fails to exercise that power, then in such situation, Article 227 can be invoked, my lord.
Then what it has failed?
Because here, my lord, what has happened, we have filed an application in the nature of, I'm using the word in the nature, and August of
Section
94.
94?
Yes, my lord.
Did
So they never issue notice, my lord. Never issued notice. Just dismiss summarily.
But then
They fail to
pass the
exercise.
order, pass the reasoned order.
They,
It may not be correct.
yes, yeah. No.
It cannot be. It cannot be. You see,
On the issue of,
understood that there is a failure of to exercise jurisdiction.
because my lord, the power is there to pass order for the ends of justice, but they have failed to do that, my lord.
The court has passed the order for ends of justice. What court found it proper?
Because
It may not suit you. You may find that this is not.
no, and another aspect, my lord, for Article 227 is that if they misapply the provisions of law, so here there is a misapplication of provisions of law.
Which provisions of law?
Because, my lord, what has happened when we filed this Section 94, this Honorable Court said that you don't have a prima facie case. So on the aspect of prima facie case, there's a misapplication of law, my lord.
No. It cannot be. Prima facie case is only on the merits. Court might not be satisfied. You may have a very good case, but then again you can raise the ground before an appellate forum, not before a revision of law.
My lord, in my humble and respectful submission, my lord, if I'll just take my lord to the impugn order, I just impugn order, my lord. My lord will see if your my lord says.
You can read the impugn order.
Yes, my
but
lord.
then
I'll just take your, my lord. to
one
the
thing you
impugn.
just remember: we will not exercise any equitable jurisdiction here. You are strictly guided by law.
Yes, my lord.
Yes, please. Where is the order?
My lord, the order starts from 356, my lord. But the part where they
So
have,
the fact of the case goes like this: that there is an earlier round of litigation between the parties, which was compromised.
yes, my lord.
Now, as per the decree of compromise, the suit property became a joint property.
Yes, my lord.
And there is a stipulation that any decision
Mhm.
with regard to the property be taken
Jointly.
jointly.
Yes, my lord.
So that is what the first round decree.
Yes.
It's well unchallenged.
Yes, my lord.
Without going into the
Yes, right. Whether it's right or wrong, my
now
lord.
this is things.
Yes.
Now there seems to be a separate or fresh cause of action.
Yes, my lord.
The
Yes,
issuance of notice and all.
yes, my lord.
Which prompted you to file a suit,
Yes, my lord.
along with an temporary injunction,
Yes, my lord.
and that initially stay was granted to you.
Yes, my
And
lord.
subsequently, on their appearance,
Yes.
you just chalked out some compromise formula,
Yes,
maybe temporary,
Yes, my lord.
and on that basis, a receiver was appointed.
Appointed for collection of revenue.
Now, what was your prayer in the suit, and what was your prayer in the?
Prayer in the suit, my lord, is I'll
Anyway,
just
let
take.
us come to the impute order. Let us see. Where is this?
It's page 356, my lord. And the operative part, my lord, is page 369.
Page.
The impugn order starts page 356, my lord.
Why so many annexes?
My lord, we annex the title suit.
You want to make this revisional court, convert this revision court into an appellate court.
No, my lord.
That is what you are trying to do. That is why you are dragging this court to the merits.
No, my lord.
Anyway,
Just-
where is that?
Yes, the operative part is page 369. My lord.
365, yes.
369, my lord.
369.
Yes, my lord.
Lawyers are there to make the things easy. You are making it very complicated.
I apologize for that, my lord. But
No,
my
there is no question or apology. The statute is sought by you.
yes,
You are
my
trying to bypass provisions of law.
no, my only difficulty, my lord, is, as I've said, my lord, is that the judge of district council court, they have
We can understand. That is what you have
that's
said
the
already.
only problem, my lord.
That was an
Otherwise-
earlier round of litigation,
Yes.
not in this case.
because this theory also
But
has a
then,
connection
see,
with earlier
we
case.
cannot, those orders cannot become a basis for this court to assume jurisdiction. That is, you should understand that.
Yes, my lord. I'm just trying my luck, my lord.
Anyway, try.
Yes,
Yes, please, where it is?
yes, page 369, my lord.
369, yes.
369, yes.
Yes.
Towards the last paragraph, my lord.
This court have perused the instant application along with the annexes.
Annexes
Isn't it?
thereto. Yes, my lord.
Yes.
After bare perusal of the documents to the application, this court is of the opinion that this instant application filed by the petitioners has no prima facie case, as it lacks material evidence to support its claims, and therefore have failed to satisfy this court as to whether the said act of digging, excavating, and prepping the land for some construction work at Borsara near the old wheat bridge which falls under the suit land was done with the permission of the actant's aim, Dorbar Hima Langren, who is the opposite party herein, and also for what purpose the said act of digging and excavating in the said area is carried out, for and who are the persons involved in carrying out the said activities. Therefore, in view of the above observation, this court hereby dismiss the instant application of the petitioners.
Yes. So what is wrong in it? Court is primarily not satisfied. Maybe order is very cryptic,
Yes, my lord.
but then it refers to merits only.
My lord, so far as in my humble and respectful submission, subject to correction of my lord.
No, the court is not there to, you are there to correct the
Yes,
court.
my lord. Perhaps my lord has a different view, but my lord, in my humble and respectful submission, prima facie case, my lord, here the court has misunderstood the principle of prima facie case, my lord. They have misapplied the principle of prima facie case. Here they are saying on one hand that yes, they admit that yes, there's construction, but they are
Who
saying
admit?
the court saying that there is a construction, but we don't know.
That is an assumption.
But we don't know who's carrying out the construction. They're not satisfied by the fact that we are saying that it's being carried out under the instruction of the respondent, my lord. Now, what proof does she want, my lord? Now, notice has not even been issued.
Your injunction is, your 94 application is directed against the
Respondent.
same.
Same,
So
who's the
until
defendant?
unless court is satisfied, there is a wrongdoing on the part of the CM, acting CM,
Yes, my lord.
then why court should pass an order of injunction?
Because,
in
my lord, that is where the misapplication of the principle of law, my lord. Because we have made a categorical pleadings saying that on so and so date, our workers went there, they saw someone carrying out construction in the land. Our workers asked those people, why are you carrying construction? And they're saying that it's being done with the permission under the instruction of the defendant, that is this aim. In spite of us making that pleading, my lord, in our petition, now the court bypasses that and saying
anyway,
that
then that is a wrong appreciation by the court. Even if we accept your submission, but then this cannot be a ground for interference and a revision of jurisdiction.
my lord, in my humble and respectful submission, my lord, subject to your lordship approval, my lord, my submission before this honorable court, my lord, is that the very fact that she have come to such conclusion is that she have misunderstood the principle of law, my lord. She's failed to exercise her jurisdiction to protect, because 94 says clearly to
Yes,
protect.
exercise her jurisdiction. There are two aspects.
No.
One is failure to exercise jurisdiction. Another is improper exercise of jurisdiction. Now, what is your case here?
My lord, in my humble and
It is
respectful.
not, cannot be a case of failure to exercise jurisdiction. Court did not refuse to take up your petition. Had it been the case that court had rejected your petition on the basis of jurisdiction, would have been a case for failure of jurisdiction. So you cannot argue, you cannot say that this
My
is
lord,
failure.
then I'll drop that submission, my lord. Now I'm saying that.
Now you can say that it is improper exercise.
Yes, my lord.
Now, this court, what this court thinks, their reading gives an impression that court was not at all impressed with the merits of it. Nothing else.
No, she misapplied the principle of law.
See, there can be a wrong appreciation of things. You may say that there was materials. You may say that there was assertion on your part
Yes, ma'am.
that some people have entered your area and they have started digging or constructing work. But then court might not find it satisfactory. But then this can be, like a matter with regard to failure to appreciate things properly. But then this never results in improper exercise.
My lord, that second limb of submission, my lord, misapplication of the principle of law. misapplication, because now she have misunderstood the
look,
principle of law, my lord.
see. 1 minute, Mr. Shila.
Yes,
See, this court is not discouraging you from advancing submission.
yes, my lord.
But then, like, trying to make you conscious of two things.
Yes, my lord.
That the petition under 227
Yes, my lord.
and the revisional jurisdiction under 115, there is a vast difference. 227 comes when the court, the trial court or the court below, the court whose order is under channel, doesn't confine itself to the jurisdiction vested and does something which utterly shocks your conscience. There you may come, you invoke 227. 227 basically is a constitutional provision, should not be invoked, you see, in a routine manner in civil cases. Second thing is that you are not remediless. So far as your case is concerned, yes, he could have approached the court under 227 had there been no remedy prescribed. You do not have that difficulty also.
My lord, the difficulty is, with your all due respect, my lord, the difficulty is this, my lord. Now there is construction which going on full swing. Now we approach the district council, the judge refers it to another judge, then another judge recuses, then matter will be transferred here, then a lot of time will be wasted, my lord.
But then if law prescribes that, can you bypass that? Just because you have exigence?
Simply on urgency, my lord, here.
You show us provision that the stipulated provision of law can be bypassed.
Because
where there is extreme urgency.
Lord, that's what we have come under 227, showing that misapplication of principle of law.
Whatever law prescribed, it takes care of urgency. And you have to go by that. We will not ignore the enacted provision of law. We can understand your difficulty.
My lord, if my lord permits me.
Had there been any discretion on part of this court to do that, maybe the court would have. But then, exercise of revisional jurisdiction, there is no discretion. You see, you do not have a right even for this finding revision. Revision is not a matter of right, unlike past appeal.
But if we are able to, my lord, in my humble submission, my lord, if I are able to satisfy certain parameters of 227, perhaps this court might.
You just give us that in this kind of situation where you say extreme urgency exists, the court or High Court would be, you see, correct in overlooking this total provision. You give us, we'll pass on it. Otherwise, very difficult. See, you are trying to basically bypass the normal procedure prescribed. We can understand, I can in my personal level appreciate your submission that the authorities therein, the judge or additional judge therein, both had a role there and maybe they will not be able to take up the matter. But then it doesn't mean just because of that, those provisions will become inoperative. Then you have to follow the same record like what you did in earlier. You file it there and then you approach here for transfer. Then we transfer. We cannot do it. You have chosen a, like a wrong remedy basically. Think about if you want to, we'll sit in the second half again. But
yes,
then
yes,
you have to satisfy that.
Yes,
that this in certain situation, this court can overlook the enacted provision of law, and then you see like assume power under 227 to give you.
Yes,
but then unless you have something, this court do not expect this court.
I'm grateful, my lord. If my lord can accommodate me second half, I'll just think about it.
The question here is interesting. This court is accommodating. Otherwise, you see, like
I understand.
Till now,
yes, my lord.
Do not see any reason for intervention.
Yes, my lord. But then I'll come second half.
This order may be utterly wrong,
yes,
but then that is only on the basis of merits.
Yes, my lord.
You can raise those things before the appellate. Yes, why? What was the purpose of recusal by the judge and additional judge there?
My lord, because all of them have had a hand in the earlier suit, my lord. 1990. Yes, my lord.
Presiding officer.
Presiding officer. All of them. My lord. We have 2 additional and 1 judge. All of them have had part of it.
This is from which area? This
Mokorwat, my lord.
This is Langrin same ship.
Yes, my lord.
You are sure this court did not have a hand in this matter?
My lord.
Who are the parties?
I don't know, my lord, the history of
that
my lord, whether my lord has taken it or not.
Right. Not Trin Semyong and all, no?
Imyong clan, my lord.
Hmm?
Imyong clan.
There may be difficulty in this.
Now, Lord, in
See,
the
there was many rounds of litigations
yes,
earlier
my lord.
also.
I think from the
Then-
90s it have started, perhaps during the heydays of my lord, perhaps my lord has taken it.
Philosophy, Young and all. That is also we are not very
Oh.
sure. Anyway, you want us to take it up at?
Second half, my lord.
We'll take it up at just second. 2:15 maybe, if not
Yes,
2:15. Just you
Yes, my
verify
lord.
the time.
Yes, my lord.
And think about, you see,
Understand, my lord.
this court would normally not like to skip the provisions.
Yes, my lord.
This court considered law is supreme.
Yes,
It is
my lord.
not that what your urgency or my urgency.
Yes, my lord.
That is all.
Bless my lord.
Daily causes. Item number 1.
May I please, your lordship?
Anti-corruption league.
Yes, my lord. My lord, 4
What
and
do you
5.
do?
Yes, my lord. 4
What
and
do you
5.
do? What is your activities, anti-corruption league?
My lord, it's an
Check all the corruption.
my lord, yes, my lord, to raise
Or you-
issues in West Garo Hills areas, my lord, against corruptions, my lord. That is the organization
Yes.
NGO.
What
Yes.
for these cases?
This is for my lord, actually, with regard to the land of the in the name
Today
of
it has
the
come for what?
This is come for my lord, actually, for we filed affidavit of service, my lord,
Yes.
for 4 and 5, and remaining 6, 7, 8, and 9
Yes.
is unserved, my lord.
Yes.
So, I therefore humbly pray, my lord, kindly allow us for dusty service, my lord.
Be granted.
It's a small prayer in my petition, my lord, because the appeal is pending for more than 7 years before the deputy commissioner, my lord, Tura.
Let us first understand the notice part.
Yes, ma'am.
6 to 9.
6 to 9, yes.
And then what about 4 and 5?
4 and 5, we filed affidavit of service on 25/11,
They have been served.
2020. My lord, yes. I've annexed the status report from the post office, my lord.
Has this court taken note of the filing of the affidavit by you?
Yes, my lord. Court last occasion, my lord, on
is it reflected in
order
the order?
dated 22/11.
Yes.
Yes, my lord.
But 4 to 9
Yes, my lord.
doesn't make any difference between 4 and 5 and 6 to 9.
My lord, no, my lord. As per our letter received from the post office for 4 and 5, already served, my lord.
Where is, where is the affidavit?
My lord,
When did you?
in the record, my lord, on 25/11/2024, we filed, my lord.
You are there for 1, 2, 3.
Yes, Lord.
My lord, in the annexure, my lord, we have annexed delivery status report, my lord.
Yes. Third, Mr. S.K. Hassan, London Council, for the petitioner, and also Mr. Thaba, London Council, appearing for the state respondent. In terms of the order of this court, the petitioner has filed a service affidavit by attaching proof of service of delivery of notice upon the respondent number 4 and 5.
4 and 5.
Step. The said affidavit has been taken due note of. Step. However, insofar as respondent number 6 to 9 are concerned, the service is yet to be effected upon them.
My lord, it is unserved return, my lord.
That is what yet to be effected.
Yes.
Stop. The learned counsel, the paragraph, the learned counsel for the petitioner a phrase for allowing the petitioner to take fresh step of service upon the respondent number 926 by dusty service.
My lord.
Prayer allowed. The prayer is allowed. Then we'll list it when.
My lord, after vacation, my lord. Because hardly
Yes, the petitioner
4 or 5 days have been.
take necessary step for service upon the said respondents and file an affidavit of service.
My lord, yes.
List this matter after vacation.
After
Yes.
vacation.
Earlier.
Hearing item number 3.
Yes.
Your Lordship can have this matter after vacation, Your Lordship. Joint request.
It's joint prayer, Your Lordship. Joint prayer.
Joint prayer. Very happy. Yes, you are for the state.
Yes, Your Lordship.
No objection.
No objection.
You are also happy.
Your Lordship, we are formal party here, so our role is limited.
So your appearance is also a formal appearance. Okay. On the joint request made by the parties, list this matter after vacation.
Authorised, Your Lordship.
Yes, Mr. Thapa, anything? No complicated matter.